What is the gateway issue on a contract's essay question? Before you do any type of analysis about whether a contract was formed, an offer, acceptance, consideration, all the big subjects I know everyone wants to jump into and immediately start discussing in their contracts analysis, there's a very important determination you have to make before you jump into any of that stuff. This is a mistake I see made all of the time because students are excited to get into the discussion of the bigger topics like offer, acceptance, consideration, whatever it is. They want to jump into that stuff, so they skip the gateway issue, and it can end up being catastrophic. So it's really important that we understand that contract law has a very important gateway issue. You have to determine what set of rules or what law governs the contract that you're dealing with in your fact pattern. You think of this as two separate universes. Article 2 of the Uniform Commercial Code, which we lovingly refer to as the UCC, and also the common law. The common law. And your contract and your fact pattern is going to be either governed by the Uniform Commercial Code or the common law. It cannot fall into both at the same time, unless you're dealing with a very rare fact pattern where it's a divisible contract, where you have multiple forms of consideration being executed in one instrument, one contract. That could be divisible and broken up into separate contracts, but that's rare. Assuming that you're dealing with a contract that's indivisible, which is 99% of the time, you're either going to be applying the Uniform Commercial Code or the common law. You can't apply both at the same time. And I see students do this all the time, right? They apply elements of the UCC, elements of the common law, because they forgot to make this their gateway issue when they started their analysis. They forgot to run through this very brief analysis, and it ends up costing them a ton of points. The one caveat here is if you're dealing with a contract's essay question and the call of the question somehow asks you to apply both the common law and UCC, which I have seen, then of course do what the call of the question tells you. But assuming that the call of the question doesn't specifically ask you to discuss both, you have to choose one or the other. How do you make that determination? If the contract deals with goods, then the UCC governs that contract. What is a good? The UCC defines a good as something that is readily movable at the time of identification. Common law is going to be services. So if the contract deals with services, the common law is going to govern that contract. And remember, the rules under the UCC and common law are going to be very different. So depending on what you find here, your analysis is likely going to be completely different. So it's very important we make the correct determination here. So off the top, one thing I like to note about services under the common law is UCC defines a good as something that is readily movable. So is land or buildings or a house, is any of that stuff readily movable? No. So any contract that's dealing with real estate, so I'm going to put a big real estate, is going to fall under the common law. So in your head, just as you're reading a fact pattern, you can think services or real estate, common law, goods, UCC. That's how easy this analysis should be. The only time it can get a little bit tricky, a little bit dicey, would be in a situation where you have a mixed contract that has elements of both goods and services in the same contract. For example, and most of the time, most contracts do have elements of both, but it's going to be very easy to establish which control. So the rule here, by the way, if you're dealing with a mixed contract that has elements of services and goods in the same contract, the question is going to be, what is the predominant purpose of the contract? Is the predominant purchase more about the purchase or sale of a good, or is the predominant purpose of the contract more about services or real estate? So, for example, say you have a contract, you're hiring a builder to build you a house, to construct you a house from scratch. Well, that builder is going to have to purchase raw materials, goods, things like lumber and whatever else that it takes to build a house. So there's going to be some goods involved. But what's the predominant purpose of that contract? Obviously, you're hiring this builder to build you a house. That's more of a service, more of a real estate contract. That's going to fall under the common law. Common law is going to govern that contract to build a home, right? So the question, if you have a mixed contract, something that deals with both goods and services, you need to ask, what's the predominant purpose of the contract? So another common example would be something that is the purchase or sale of a good plus shipment. So say you're buying 100 reams of paper from a paper supply company, but they're also agreeing in that contract to ship that paper to you. Well, shipping something is a service, right? So it does have elements, that contract, you're purchasing goods, but they're also in the same contract agreeing to ship those goods to you, which is a service. So what controls? We'll ask, what is the predominant purpose of the contract? And typically there, the predominant purchase is the goods. You're purchasing reams of paper. Yeah, they're shipping it to you, but the predominant purpose, you want that paper. You're entering that contract to obtain the good of paper. So UCC is going to be the predominant purpose here. The goods aspect of it is going to be the predominant purpose. So the UCC is going to govern that contract. So one other, if you just want to have some factors in your head, there's 3 factors that I kind of put under the common law that you can think about if you're dealing with a mixed contract. You want to think about, I won't write them, just to briefly go over these. Under the common law, you want to think about what is the knowledge, expertise, or skill required to perform this contract? What's the quantity we're dealing with, and what's the price? The lower the quantity, the higher the price, and the higher the knowledge or skill requirement, that's going to typically be factors that point to something that's more service-based. For example, say you're hiring a painter to paint a painting of you, right? You're spending thousands of dollars hiring an expert painter to make a artist rendition painting of you. Well, you're actually entering a contract to purchase a good. A painting, under the definition of the UCC, is a good. It's readily movable at the time of identification. So a painting, the purchase of a painting, could be a good. But here, in this situation, you're spending thousands of dollars hiring an expert to make something very low in quantity, one single painting. Those factors are going to point to a service contract. The predominant purpose of that contract is more about the knowledge, skill, expertise of that painter painting that painting. The actual act of the service of creating the painting is more of the predominant purpose under those facts. So again, the predominant purpose can be a little bit tricky sometimes if you're dealing with a mixed contract, but those are some of the main factors you want to think about. How much knowledge and skill is required here? What quantity output are we dealing with? If you're dealing with something where you're hiring a painter to make hundreds and hundreds of paintings, and you're buying a quantity of 200 paintings, that might be a different analysis, right? Especially if there's less of a skill requirement and it's less of a, and the price goes up, less of a skill requirement and the price goes down, then you could be dealing with a goods contract there, right? So it's going to be very fact specific. Those are going to change a lot. Those factors are not conclusive, but just something to think about in your head. Obviously, you could be dealing with a contract for the purchase of some sort of specially manufactured good that would still be a good, but does require knowledge and skill to make that good. So again, it's going to be very fact specific, but if you're dealing with a mixed contract, the question is going to be, what is the predominant purpose of this contract? Is this more about the purchase or sale of a good, or is this more about the service aspect of the contract? Once you determine that, you will determine whether the UCC or common law governs, and you're ready to move on in your analysis. And one more note to make on the common law versus the UCC is simply going to be this, and this is something I just like to note, that the common law if you're ever wondering what the difference between the common law and UCC is, something just to remember in your head is that the common law came first, right? The common law has been around since the beginning of time, since the beginning of law and formation. Common law was around long before the UCC was written. So the common law is what contracts were based off of. This is what the law governing contracts was for many, many decades and years, right? And so what happened over time, though, as contract law evolved as a subject, what you had was very harsh results. The common law tends to lean towards very binary findings. The common law is very strict. It says things like, we have to have, in order for there to be a valid, enforceable contract, X, Y, and Z have to happen exactly like this. And if there's anything wrong with that, no contract. So under the common law, a lot of times you get very harsh results. So what happened? The drafters of the UCC came along and said, okay, look, the common law is leading to some very harsh results. Let's look at the actual intent of the parties to the contract. The UCC is much more willing to plug the gaps, consider the party's intent and the good faith intent of the parties. So the common law is going to be very strict, very binary, it has to be exactly this or nothing. The UCC is going to say, well, let's look at the good faith intent of the parties, and if we need to plug in some gaps here and there to make this work, that's going to be okay. But we really want to think about the intent of the parties. So just remember, common law was around first. It's very harsh, very strict, very formal. So the drafters of the UCC came along to try and mitigate some of this, I would say, harshness. So just the only last note to think about as we continue, and you can see the differences between the common law and UCC, it's typically going to be common law is very strict, very harsh. UCC is a little bit more lenient, okay? So basically that is going to be everything you need to know for your gateway issue. When you sit down to write a contract law essay, very important that you hit this gateway issues. You knock this out. Before you even read the fact pattern, I tell students to put this heading down on your essay. If nothing else, you see you have a contracts essay to write, before you even read the fact pattern, at the very top, put this heading, UCC versus common law. Something that you're going to see as you begin to write your essay, so it's in your head as you're going, and that's going to help, because if you forget to cover this gateway issue, the results are often catastrophic, because you're going to end up applying the wrong law to the fact pattern, and you're going to get no points. So all that you have to remember is this is your gateway issue. You want to run through this. But then once you get past this gateway issue and you know what law governs your fact pattern, you're going to be ready to go, get into the more exciting topics of contract law, which we're going to be covering in our next videos. But until then, I wish you all the absolute best, and I'll see you at our next video.